Good morning, colleagues. Thank you for attending and a warm welcome back to the Poker Essay Ponder Virtual Presentation Series. We will commence with a short presentation lasting about 30 minutes, a question and answer session of 10 minutes, and conclude with a lucky prize draw for a Take-A-Lot voucher worth 1,000 rands. You are welcome to field questions in the chat box during the presentation, which will be answered at the end. We had over 200 registrations for this session, so some colleagues are still coming in, and please note that the webinar is being recorded and will be up on our Poker Essay website. This morning, our guest speaker, Vishen Pillay, will enlighten us on a trending and very interesting topic, intellectual property explained. We have all heard of it, but what is it exactly and why should you care? This session provides a primer on all things intellectual property, including why it's important for higher education institutions, as well as businesses and small companies on a budget. Our guest speaker today, Vishen Pillay, is a partner at Adams & Adams Attorneys, the largest intellectual property law firm in South Africa. He has a background in electronic engineering from UKZN and is an admitted attorney as well as a qualified patent attorney. Having over 17 years of experience in IP, Vishen specializes in assisting his clients to protect their inventions in the fields of electronics, software, artificial intelligence, quantum communication and computing, radar, telecommunications, mechanical engineering, electromechanical engineering, and biomedical engineering. In particular, he deals with all matters relating to filing and prosecution of patent and design applications in South Africa and abroad, as well as IP strategy. Vishen has drafted and successfully prosecuted patent and design applications on behalf of many South African universities, science councils, US Fortune 500, and South African top 100 companies. He currently serves as one of the members of the management committee of Adams & Adams and was previously appointed by the South African Department of Science and Technology to serve on the advisory board of the National Intellectual Property Management Office. Vishen is also one of the co-founders and current co-chair of the American Intellectual Property Law Association African Subcommittee. Thank you, Vishen, and welcome.
Thank you so much, Ayabulela, for that introduction. I must always remember to make these bios a bit shorter. So thank you for reading the whole thing out, though. But everyone, thank you. It's an absolute honor and pleasure to be with you this morning to discuss a topic that I'm very passionate about. And it's not just because I'm an IP attorney. It's intellectual property. Hopefully, it's 30 minutes is a really short time to discuss all the topics in quite a lot of detail. So I'm going to be touching on the subjects on a high level and just try to give some sort of real world examples from my practice that deal with some of these topics. And hopefully by the end of the presentation, we'll all be a bit more sort of au fait when it comes to the various forms of intellectual property and what intellectual property is all about. So I'm just going to share my screen quickly. Let's just do it this way. Ayabulela, I'm just going to ask you to tell me if my screen is successfully shared.
No, it's not yet. Okay, there it's coming. Yes, it is. Thank you.
Oh, fantastic. Okay, great. So yeah, as Ayabulela gave the introduction, I'm Vishen Pillay. I'm a partner at Adams & Adams, and we are the largest IP law firm in Africa. And intellectual property. What is intellectual property? I think we've all heard the term or the phrase intellectual property, but what it is actually, it's just an umbrella term used to describe effectively fruits from the human mind that are reduced to a tangible form. So when we talk of intellectual property rights, we're talking about the various rights that are given to protect the various forms of intellectual property. And intellectual property rights effectively covers all range of IP, which is including trade secrets, know-how, trademarks, patents, registered designs, and copyright. And during the discussion today, I'm going to be taking you through all these forms of IP and just sort of touching base on what these forms of IP are. And you'd find that hopefully by the end of today's discussion, you'd be able to identify products. I mean, simple products sitting on your desk, your computer in front of you, and easily be able to point out the forms of IP that resides in there. Because whether we like to believe it or not, intellectual property is everywhere. It's all around us, and we cannot get by a day without seeing intellectual property in some form or the other impacting our lives. So, as I say, that the law recognizes and protects the various forms of IP. First up, I'm going to be talking about patents. And it's not just because I'm a patent attorney. I believe that patents can be a really strong legal instrument for any organization, especially from a university front when you are dealing with researchers that are innovating, doing really fantastic things. We need to be protecting that IP. And patents are generally a very excellent vehicle to protect new technologies. And you'll see that the definition is effectively it's a legal instrument used to protect an invention. And when we talk about inventions, it could really be anything. I mean, an invention can be a new apparatus, a new article, a machine, a new product, a process, a chemical compound. It could even just be a new method of doing something. Generally it's around technical ways of doing something. So if you're a mining company, you could have a method of extracting more gold or more platinum from ore, for example. That's a method that can be patentable. And then, of course, new computer programs. A lot of people believe that computer programs are not patentable, but they are. They can be patentable, provided it meets certain requirements. Now, you'll see that the common thread of all these things is that it needs to be new. And that's part and parcel of the requirements for patent protection or valid patent protection. It's that the invention needs to be new and inventive over existing technologies in order to be patentable. So new is effectively that an invention needs to be a world first. So objectively, it's a black and white question. It's either there in the world or it's not there in the world. So that's fairly easy to understand novelty or newness. But then inventiveness. What is inventiveness? Inventiveness means that an invention, even if it's new, shouldn't be an obvious change over existing technologies. So it shouldn't be an obvious variation of a solution or something like that in order to be patentable. So the first requirement is very objective in nature because it's either there in the world or not. Inventive, you will understand it's very subjective in nature because what's obvious to me is not going to be obvious to you or obvious to the courts. So each case has to be taken on a case-by-case basis. I always use an example of a simple pen. If you and I lived in a world with only black pens and you came up with a red pen, just by virtue of the fact that it's new, you'll meet the requirement of novelty. You'll have something that's new. But then the question is whether you have something that's obvious or not. Is having a red pen obvious in view of having a black pen? Now, I'll think it's very obvious. I'll just tell you that you're just changing the color from black ink to red ink. But if you can say, well, look, Vishen, it's not so obvious. Red ink has a different viscosity and thickness to black ink, and you needed to change the tip of the pen somehow to deal with it. Now you're dealing with something that's not so obvious anymore. So that's why I say it really needs to be taken on a case-by-case basis. So the main takeaway points when you're dealing with patents is that this requirement of novelty means that you yourself need to keep this invention secret before you file a patent. Because once you tell people about your invention and there's no non-disclosure agreement in place, you can't go back and file a patent for it because it's deemed to be in the public domain. So the main point when dealing with patents is that you have to file a patent before you disclose your invention publicly, or even before you start using your technology publicly. And if a disclosure, or you have to tell people about your invention, the best thing to do is use a non-disclosure agreement if a disclosure is unavoidable. Now we're talking about novelty and inventive steps. It's important to know that in South Africa, our South African Patent Office at this stage doesn't examine patents to tell you whether your invention is novel and inventive. So if you file a patent in the South African Patent Office, it's automatically going to be granted at this stage. We are going to be starting to examine patents in the future, but at this stage, it's still going to automatically grant the patent. Other countries are different. For instance, if you file a patent in the US or Europe or China or whatever it is, it's going to be picked up by a team of scientists and engineers in the patent office and examined to see whether or not they believe it's novel and inventive. So that's why the step of novelty and inventiveness is a very important question to ask yourself right at the outset. So you may be asking yourself, well, if South Africa doesn't examine patents, why should I worry about that? Well, it's important because if you ever had to enforce your patent down the line, if your patent is not novel and inventive, there's no way that you can enforce that patent before the South African Patent Office and before our courts. So, of course, the main benefit of having a patent, as many of you would think about, would be that if you have something that's new, you really don't want anyone else to do anything that's copying you. So of course, that's a very valid reason why people will file patents. But of course, there's other softer aspects of filing patents. There's a commercial benefit of having patents in place. And an example for my files would be a company like Advanced Imaging Technologies. It's a local startup client. It was a really small client when they started off. And what happened was it was a university professor that realized, look, in the mining environment, you'd have these conveyor belts that ran for kilometers. And if there was a break on one of these rubberized conveyor belts, you'd never know about it until it was too late. All the ore on these conveyor belts that run for kilometers would just fall off, and it was a massive multi-million rand and multi-million dollar exercise to sort it out. So what the inventor here did was that he looked at these sort of reinforced conveyor belts, and he realized that inside these belts there's a metal cords in there. These they label 24. There's metal cords in there that strengthen the conveyor belt. So he thought of an idea of actually magnetizing it. So he magnetized these cords. So he used a giant magnet. Effectively, he made these cords magnetic, and he used the sensor 16 to detect if there was any broken cords. So very early on, you would be able to tell that there's breaks in this line or potential problems in this conveyor belt. So he filed patents for it, many patents actually, and we got granted patents around the world. And eventually, Continental, many of you remember Continental as the tire manufacturers. They're known as Contitech, which is their technology arm. They eventually ended up buying off Advanced Imaging Technologies. I mean, all of this is in the public domain, so I can talk about it. And the inventor, Dr. Alport, given me his blessings to talk about it. So they actually eventually ended up buying out Advanced Imaging Technologies. And at that stage, the company's assets were largely surrounding the patent. So you can understand at that level that they didn't file the patents, or they probably filed it to stop competitors. But the actual value that they extracted down the line was not from really suing anyone on this patents. It was actually the commercial value that another party, a third party, saw in the value of having this technology. So that can be just as an aside, another value of having intellectual property. Now, that is patents in a broad nutshell, but there's another form of intellectual property that's almost linked to patents in nature, and that's registered designs. Now, whereas patents protect the novel and inventive aspects of your design, what a registered, of a product, what a registered design does, and they sometimes call industrial designs, they protect the appearance of articles. Now, in South Africa, there's effectively two types of registered designs. One is a functional design and one is an aesthetic design. Now, aesthetic designs have features that are judged solely by the eye, and functional designs have features that are necessitated by the function which the article is to perform. So I know that can be tricky, but the way to think about it is that aesthetic designs, it just really looks nice. It looks really pretty. Functional designs, there's a bit more to it. There's functional aspects to these designs. So the example I like to give is a simple chair. I could have both. I could have an aesthetic design because my chair looks really funky, but I could also have a functional design if I design my backrest to give me a specific lumbar support. So there can be overlap between these forms of, between registered designs as well, but effectively it protects the appearance. So how it links back to patents is that whereas patents protect the novel and inventive aspects, registered designs protect the actual appearance. Where now an example would be, I'm going back to my trusty pen example again here. If you had a pen, the patent is protecting a housing which encloses this ink-filled filament and with a fluid distribution mechanism coupled to it. So it doesn't matter what my housing looks like or what my ink-filled filament looks like or my fluid distribution mechanism. If it has all of those three features, it's going to infringe my patent. But the pen on my desk, my big pen can look much different to your fancy Parker pen on your desk. So I can get protection for my design, you can get protection for your design, but they're still falling within the scope of the patent. So it's just a different level or scope of protection, but it effectively is protecting the appearance, which can be different. So really, you can protect anything that has an appearance. It can be a new tire tread, a new shoe or garment. It could be new shape of a vehicle, graphical user interfaces for computer programs, new electronic circuit boards, the printed circuit boards, you can protect that. Really anything. And in order to be protectable, we talked about novelty and inventive step when it comes to patents. Registered design also has their set of requirements in order to be valid. The requirement is that it needs to be a world first, just like patents. But for the case of aesthetic designs, it needs to be original, meaning that you needed to have expended your own skill, labor, effort to come up with this design. And when dealing with functional designs, it mustn't be commonplace. So that's more like inventive step. it needs to be something that is not common in this particular area of design, not commonplace to have specific design features. So really speaking, those are the requirements for functional designs, which are not examined in South Africa as well. Whereas in other countries, they do examine designs for these requirements to see whether they meet it or not. Now, as I mentioned, it's part of the requirement of novelty that you need to file these designs before you launch to the public. But of course, there is a 6-month grace period in South Africa, which we're very fortunate for, to file these registered designs. So you can release your design into the public and then go back within 6 months and file a registered design. For my clients, for example, that's quite useful if, for example, in the fashion industry. I have clients in the fashion industry that launch a product, but they're not really sure which design is going to really do well financially. So they would launch a range and look to see which one does well financially within that 6 months. And then that's the design that they file for, because that's the one would probably be replicated by their competitors. So whereas we spoke about patents, and the example I gave was of an organization that didn't use the patents to stop people from infringing, but they used their patents to access commercial value in their technology. I have another client that actually uses their registered designs here to sue other people that copy their designs. And this is a company called Maxi. Some of you may recall it, those of you that have Buckies or 4x4s. They make bull bars, roll bars, and sports bars for Buckies and sort of SUVs. So here you'd see that they came up with this really fancy design, and they have competitors that copy these designs. They launch to the public, and then a competitor would launch a product that looks almost identical or very similar within a few months. And my client has spent millions into R&D coming up with these designs. And what happens is that we are able to extract value by leveraging the designs that we found to stop these third parties. And we've successfully stopped these third parties in the past. And this company, Maxi, continues to protect their designs. Now, the other form of IP is trademarks. Now, trademarks is more in your face. I think everyone here knows exactly what a trademark is, because you can't, I think in this commercial world that we live in, you can't put your TV on or switch your phone on or walk out the door without seeing trademarks in action. They're legal instruments used to protect marks that identify the goods and services of one person and distinguishes it from the goods and services of another person. So you can see that the main thing here, the main theme for trademarks is this whole concept of distinguishing. You want to be able to have a trademark that distinguishes you from competitors. So even the definition of a mark, it's any sign of capable of graphical representation, which is be able to use in course of trade in relation to goods and services, which has the purpose of distinguishing your goods and services from those of your competitors. Similar goods and services from competitors, similar goods and services. So that mark, being capable of graphic representation, can be anything. It can be names, devices, which what we call logos, we call them devices in the industry. Letters, numerals, shapes, configurations, colors, container shapes, all of that can be registered as trademarks because they're capable of graphic representation, which I've highlighted there. Interesting story is that once Harley Davidson tried to trademark the sound of their engine note. I think any of us here, or many of us, can hear a Harley Davidson down the road and really know that that's a Harley going down the road, because their engine notes are so distinctive. It's really loud and it's really powerful. And they tried to put the sound bar on a bar graph and file it as a trademark. So really anything that's capable of graphic representation or putting down on a paper can be filed as a trademark. Over time, these become the most valuable forms of IP. And the reason is, which I really should have mentioned earlier, is that patents and registered designs, for example, have a limited lifespan. Patents only last for 20 years, and then it falls into the public domain for anyone to use. Registered designs, it's 15 years for aesthetic design and 10 years for a functional design, and then it falls into the public domain, and anyone can use it. But trademarks last forever. You can actually have a trademark that's going on for hundreds of years. Coca-Cola is a perfect example of that. It's a trademark that's been around for over 100 years, and it's probably going to be around for longer than you and I are going to be around for. And in time, it becomes so valuable that it's worth billions and billions of dollars. Trademark for Coca-Cola is probably worth more than any of their fixed assets in the world. That's how powerful the brand Coca-Cola is. In South Africa, there's registration. There's a formal registration process, just like patents and registered designs, to file a trademark and get a registered trademark. But there's also common law rights, meaning that if you can show the courts that you have a reputation in your trademark, you will be able to, the courts will enforce that trademark for you. But of course, it can be problematic because you have to show the court that you actually have a reputation to use that trademark, meaning that you'd have to get market research surveys and all these fancy things to be able to show the court that you have a reputation. So that can be actually, multiples of the cost of filing a trademark. So, but it is available. But as I say that, you start to realize that all of these things that I'm talking about today, all these forms of intellectual property, they don't exist in isolation. They dovetail together to prop up any business or any institution. I mean, if you're a university providing academic sort of outputs as well as a research or learning, higher education learning, your brand, your name is your trademark. That is part and parcel of it. So it really sort of holds water internationally and locally. Whereas the other forms like patents and registered designs would normally be something that comes out of different research groups or different faculties of the university, for example. This is just an example of trademarks, from example from our files. Of course, everyone here knows what a Coca-Cola bottle looks like. This is the red and white logo. But Coca-Cola is such a well-known and powerful brand and trademark that the color combination, red and black, they almost claim a monopoly on it. So, we were able to stop this infringing brand, not necessarily calling themselves Coca-Cola, from using the color combination. Because red and white in relation to cola-flavored beverages is almost in the realm of Coca-Cola. Everyone knows that red and white, if you want a cola-flavored beverage, is going to be Coca-Cola. So it gives you the power available within a trademark to be accessed. The next form of intellectual property is copyright. Now, copyright is a bit of a tricky form of IP because it's an exclusive right given by the law to any original works that are created. Now, original means that, just like when we spoke about designs, it means that you needed to have put your own effort, labor, steam into coming up with this work. And when we talk about work, really it could be anything that is literary, musical, artistic. It could be film, sound recording, broadcast, computer programs, published editions, and program carrying signals. Each one of these forms of copyright has its own sort of specific rules for coming into existence. There's no formal registration of it except for films. So it's an automatic right that gets generated as soon as you reduce these forms of IP or copyright into a tangible form. So if I have an idea for a book, there's no copyright there. But as soon as I write out the story, then I have copyright that comes into life. All I have to do is put the C with the circle around it, put my name and date, and keep accurate records. That's all I can do because there's no formal registration process in South Africa. So it can be quite tricky because it's the cheapest form of IP to get or one of the cheapest forms because there's no formal registration. But it's one of the most expensive forms of IP to litigate in courts because it becomes a he says, she says. So that's why when you're doing any of this, if you write a play, if you write a novel, if you write a manual, anything that you put pen to paper, you need to keep accurate records for copyright purposes so that you can show down the line that, hey, wait a minute, I didn't steal this from anyone. I've got copyright in this. One of the tricks used in the old days by novelists is that they used to send a copy of their novels to their lawyer, their girlfriend, their wives, sometimes it could be both, and they would effectively send that manuscript that they would prepare to themselves and all these parties by registered mail. So if there was ever a dispute of ownership of copyright, they would just tear this registered mail open in courtroom and produce the manuscript that they have. So it is almost like a timestamp, a time and date stamp. These days it's easier. You can have emails, you can have email trails, you can stamp it by a commissioner of oaths, all these various things just to put a date associated with the copyright. So just as I mentioned, you need to be careful about some of these forms of copyright because something like computer programs, if you get an external developer to develop for you and they're not your full-time employee, they will own the copyright in the computer program, not you. So as I mentioned, each form of IP needs to be looked at critically. So it's always useful for any organization to take stock of their IP, to see what you have, to do an audit, to see what you have, what you don't have, where you should be tightening the belt to protect your IP so that it doesn't escape. From a university context, we're quite fortunate in that the South African government came up with something called the Intellectual Property from Public Funded Research Act, meaning that now IP in the form of patents and so forth cannot just get lost to the public. If you're using South African or taxpayers' money, government money to do research and development like they do at universities, it needs to be protected. before it can be released into the public domain for anyone to use. So it's just to benefit the South African public. You know, we want to benefit of whatever we want benefit from whatever IP we can protect. The last form of IP that I'm going to talk about today is trade secrets and know-how. This is sort of no formal registration as well, so it's relatively cheap. It's effectively confidential information and ways of doing things that imparts holders or imparts value to the holders that you don't really want anyone else to do. And that can be really anything. I mean, it could be something like the secret formula for Coca-Cola, the 11 herbs and spices of Colonel Sanders. It could be anything that you can keep a secret. Of course, the benefit is that you can keep it forever as a secret. I mean, I've tried during lockdown to recreate the KFC recipe. I'm sure many of you did that as well during lockdown a few years ago, but it really didn't come close. So that's why I say that it can be a very valuable form of IP if you can keep it a secret. Of course, the drawback is that once it's in the public domain, it's, you know, the cat's out the bag. There's nothing you can do to go back and try to put it back in the bag. So it's important that if you have something that you want to keep a trade secret, it's not something that you can easily reverse engineer. I mean, if I buy myself a KFC piece of chicken, if I eat it, I really wouldn't be able to tell you, you know, how to reverse engineer that. Or if I take a sip of Coca-Cola, I'm not going to know what's going in there. So that's why it's ideal for things that are easily or not easily reverse engineered. But if things that can be reverse engineered, it's really not the form of IP that you want to look at. And the way to protect oneself here is with confidentiality, non-disclosure agreements, and the like. But like I say, it's only a secret is only good as you can keep it a secret for as long as you can keep it a secret for. Sorry. So really, it's your ability to keep a secret is what would work for maintaining secrecy. So just in summary, you know, we've discussed the main forms of IP. We discussed patents, copyrights, trademarks, designs, and trade secrets. And you'll see that the requirements for each vary. You know, for patents, it needs to be novel and it needs to have an inventive step. Copyright, it needs to be original work that you need to reduce to physical form. You have to write your novel out. Trademarks, it needs to be capable of distinguishing your goods and services from your competitors. Designs, it needs to be new and original, new and not commonplace. And trade secrets, you need to keep it confidential. So, you know, those are the important points to remember when dealing with IP. These are, and these points can be summarized. You know, it's a common thread through all of this. And that's why I get really excited about IP, because it almost taps into human ingenuity in its essence. You know, it deals with the common threads of originality, distinctiveness, novelty, and inventiveness. So all of these common threads are really, you know, what can power an organization. You know, it doesn't matter whether, you know, university or a company, it can really power it. In university context, I often give lectures and presentations to universities, and I always go back to the Google example. I mean, it was founded by, you know, two students, you know, two research students, and, you know, they were at Stanford at the time, Larry Page and Sergey Brin. And just because they were research students at the time, they managed to extract a lot of value, and the university owns those patents, which they received, you know, hundreds of millions of dollars in royalties from Google, just because at the time these guys were research students, and they were, sorry, I don't know why this is going back, but they were research students, and they had to assign their rights to the invention over to the university. So even universities can benefit from IP, not just companies. So effectively, IP rights, in a nutshell, you know, it can set your business, or it can set your offering apart from your competitors, and it protects effectively a competitive advantage. So it's effectively legal tools that give you it gives you the edge. You know, it gives you a competitive advantage, and it gives you a legal monopoly that's allowed. Patents can be, or IP can be licensed, sold, and it provides a revenue stream. It can offer your customers something new and different. It can even be part of your branding campaign. I remember Audi had an advert many years ago that it had thousands of patents, more patents than the space shuttle in their offering. So you know, that's another benefit of it, to have a branding value of your patents on your IP. And lastly, it could be used as security for loans. Many of you would have watched Shark Tank, Dragon's Den, and all those shows. And a lot of the times, people, they would ask, you know, what is the IP? Do you have a patent for this? So it protects that investment. So it can be used as security. So this is sort of the last slide. I'm sorry, my animations, my slides just got away from me here. But you know, effectively, you'd understand now from this, this 30 minutes or so of me talking nonstop and very fast. I apologize for that. But that IP is everywhere, so in your phone, in your pocket, I guarantee you that there's all the forms of IP in there. There's trademarks. You look at your brand name of your phone, it's either one of the big names, I'm sure, and you're going to have a trademark. They protect their trademarks quite aggressively. You're going to have registered designs. Incidentally, it's the registered designs for this phone, which was the subject of the patent and debates that Apple and Samsung had around the world. It's just that in America, they call them design patents instead of registered designs. Samsung, for example, files registered designs for their graphical user interface, and each one of these icons that you see here have registered designs filed for them. There's patents, of course, for the actual core technology within the phones. And it's something as simple and trivial as, the slide to unlock. You click the screen and then you slide it and then it unlocks the phone. That's a patentable technology. There's copyright in the source code, the code that's actually underpinning this phone that we're looking at. And lastly, there's trade secrets, and trade secrets can really be, how to put the phone together. Where are they getting their batteries from? That could be a trade secret. A trade secret could also be something like their distribution networks. So you can understand that it's not really limited to the phone itself, but it could be wider. And that's why I say intellectual property is really everywhere. And from that perspective, it's something that one needs to almost step back and take a look. And I guarantee you that you're going to be seeing products and offerings in a whole different light. So that's me in a nutshell. I know that it was quite fast, and again, I apologize. But we just had a little time to cover quite a lot of complicated topics. So thank you all for your time, and again, it was a pleasure to be here.
Thank you, Vishen. Colleagues, we will now proceed with the question and answer session. So I'll be reading some questions from the chat box. Hi, Vishen. Did I understand you correctly that in South Africa, patent applications are automatically approved without interrogation?
Yes, correct. So at this stage, if you file a patent application in South Africa, if I file a patent for a spaceship to take me to Mars and back, I will get a granted patent in South Africa. So at this stage, there's no, and you can understand, we really didn't have teams of scientists and engineers to spare to man a patent office to examine patent specifications. We're actually gearing up now, and I'm pleased to report that the South African Patent Office will start examining it. And how it works, how it worked when you're talking about the challengeability of the patent, effectively to enforce a patent in South Africa, it needs to be valid. So immediately when you try to enforce an invalid patent against somebody, they'll immediately come back and say, well, this patent is not novel, inventive, it's not patentable, it's not valid, so it cannot be enforced. And for that reason, it shouldn't even have been granted in the first place. So effectively, if you want to sue somebody or somebody sues you, the courtroom turns into this examining patent office. So the South African courts will not enforce a patent if it's not valid, if it's not novel and inventive. So, in a nutshell, that's what happens. The courtroom transforms into this examining patent office in practice.
Okay. The second question is, what considerations should I have when I'm planning an IP strategy for a new market?
Okay. So the IP strategy is that you need to cover all the IP bases. Look to see the various forms of IP. I had another slide in here, which I kind of took out. It's a whole process when dealing with IP. It's the conceptualization process. Within the conceptualization process of your business, you then look to see which forms of IP form part of that. If I got this great idea to do something, is it patentable? Is there any registered designs there? What copyright do I have there? Do I have a cool name to think of for a trademark? Am I using the right steps to think of a trademark? So the whole thing of a trademark, for instance, is capable of distinguishing. So you don't want to have a trademark that's descriptive of what you're offering. So you can make up, the best trademarks are made up words. Xerox is a made up word, so it's a good trademark. Or if you're using existing words, rather use words that have nothing to do with what it is that you're trying to sell. If I'm a company like Apple and I'm selling fruit and vegetables, it's a really bad trademark because it's kind of describing what I'm selling or it's related. But if I'm selling computers and phones, it's an excellent trademark because it has nothing to do with what I'm selling. So it's things like that that you need to bear in the back of your mind. I think reach out to IP attorneys. IP attorneys normally offer free consultations where you can actually bounce off these ideas. And IP attorneys are normally sort of quite, my practice is largely based on startups. I generally assist quite a lot of startups getting their projects off the ground where we go through all these forms of IP. So get yourself into one of these workshops, and join or various sort of chambers of commerce organizations, or just reach out to IP attorneys in general, and they will be able to guide you. But for any offering, you need to have IP strategy as part of your offering. I mean, South Africa is quite far behind in that space. But if you, for instance, go to the US, Silicon Valley, for example, the discussion is very different. They want to see what IP you have. They want to see what great technologies you have that they can protect before they invest. And I think as South Africa gets to a more entrepreneurial, knowledge-based economy, IP is going to be forming more and more a cornerstone of that.
Okay. Next question is there advice you can give for higher education institutions, especially where they partner with students to create new innovations?
Yeah, so with research organizations like higher education organizations, the good thing is that all higher education organizations in the country have something called technology transfer offices. And there you'd find highly skilled IP professionals that will be able to guide the ownership considerations. Some universities, for example, and it really, each university has their own IP policy, which will govern how IP is dealt with within the university. For instance, if some universities have a thing where they say that if it's undergrad students partnering with the university, the undergrad students can own the IP. It's fine. But as soon as you're a researcher at the organization, you're a PhD student, you're a master's student, whatever it is, or you're employed by the university in some way, the IP will belong to the university automatically. So it really depends on the university. So I would advise that you reach out to them. All of the universities in South Africa have technology transfer offices that really are skilled professionals and they know what they're doing.
Thank you, Vishen. The next question is, very often you have an idea, however, you do not have money to execute it, and you want to partner with someone who will fund it. How do you then protect your idea?
Okay, so yeah, that's a good question. There's two ways to go about it. There's three ways. For instance, well, actually, there's maybe more ways. You could ask somebody for money, and they would give it to you to file a patent application. The other option is that various government-funded organizations, if you are showing them that you do novel and inventive stuff, they give government grants which cover IP costs as well. That's available. So the Technology Innovation Agency, TIA, is a good example of that. The DTI, other organizations that fund would be the likes of your IDC and so forth. So reach out to government-funded organizations. They're quite, our government is really trying its best to foster innovation and entrepreneurship within the country. South Africans, we have this nasty habit of buying everything offshore, not thinking that we have skills in the country to do it ourselves, but we have brilliant people in this country. We can do it ourselves. So, that's what they're fostering. And, so look for those organizations. The last option is do it yourself. You can file a provisional patent application at the South African Patent Office yourself. The cost is 60 Rand. That is the official fees. When you go to an IP attorney like myself or any other patent attorney, you're paying for our time. And because we relatively, I don't want to toot our own horns, but because we're quite skilled professionals, actually all patent attorneys have legal and technical backgrounds. You're going to have to pay for that, and it doesn't come cheap. So the best step you can do is give us the tools to work from. If that is not available to you, draft out a patent document yourself. Look and read patent specifications. You want to describe your patent and your invention with as much detail as possible in that application, and then file it at the patent office before you talk to anyone. Hopefully within this, and then effectively you get a year worldwide of patent protection. And I didn't go into it in detail because we didn't have time, but the process is that you would file a provisional patent application, which secures your rights to the invention worldwide for 12 months. And then you'd have to decide which individual country you want patent protection in, because patents are territorial in nature. So that provisional patent application can be filed by anyone. So I would advise you filing it yourself, putting as much technical information to enable somebody to be able to build whatever it is that you want to do or provide the same services that you want to provide. And once you file that application, you can then take your chances and then disclose to third parties. And then, of course, if there's money flowing in, you want to be speaking to an IP attorney immediately. Because even if you file it yourself, it kind of forms the foundation of your entire patent portfolio going forward. So if you file something that's shaky, effectively, there's a shaky foundation going forward for your technology, and that can be quite tricky. So let's have a look at it as well. And then lastly, the other option is to use NDAs. Sign an NDA between the third party and tell the third party, look, I filed a self-file provisional, or maybe I don't have a provisional application, but you're disclosing this to this third party, and they're going to be keeping it confidential. And if they partner with you, you can negotiate with them to fund the patenting costs, for example. But NDAs are very useful if you have no choice but to disclose. And you can find them online, or you can just reach out to an IP attorney. Sometimes I just give them freely out with a big warning that this is a very dangerous thing to do. Normally, I like NDAs to be targeted per disclosure, but I, for example, have NDAs that we call them vanilla NDAs, or your precedent NDAs. But I don't like to use them, but I have them available if you need them.
Thank you, Vishen. The next question is, if I make a change or new subsystem to an IT program or ERP and pay for it, does the patent or design belong to my institution or to the ERP provider?
Okay, so it really depends. If there's a pre-existing agreement with the ERP provider, you need to investigate that. Normally there is, but if there's not, and if the ERP provider is not an employee, they are a full-time contractor, for example, where you pay them per engagement, they will own the copyright. They will own the copyright until there's a written agreement saying that, hey, wait a minute, they actually don't own the copyright, you own the copyright. So that's important. When dealing with patents and registered designs, it also depends on the agreement in place. Because in terms of our Patents Act, the only person that can apply for a patent, for example, is the inventor, or a person who has effectively gotten the rights from the inventor. So if I'm sitting here as a research institution, I'm a university, and I tell somebody what to do, but I don't really come up with a solution. I just say, hey, you know what? I really need this thing to be sorted out. Can you please help me? And they do the innovating. They will own the IP. They will be the inventors, unless something says that, hey, wait a minute, the university needs to own it. That's why it's important to have agreements in place with service providers that the IP will be owned by the university or whatever it is. But yeah, so it really depends on, it's a question of fact, who developed it will own it, unless there's an intervening agreement that says that they shouldn't own it.
Thank you, Vishen. The next question is it possible to get a ballpark estimate of how much it would cost to register a patent or trademark, and how long does the process take?
Okay, so patents in South Africa, a provisional patent application ranges from anywhere from about 15,000 Rand for really simple inventions, 15 to right up to about 50,000 Rand. And actually sometimes more if it's a really complicated, you're filing a patent for a nuclear reactor or something like that. It's not going to be 15,000 Rand. So it really depends on the level of complexity of the invention, but 15 to 50 is a good ballpark figure. But most simple to moderately complex inventions is generally between 20 to 30,000. I mean, that's generally the ballpark figure. When it comes to the timelines, you file the provisional patent application, and then you have 12 months to decide which countries in the world you want to file patents in. It's at that stage patents become expensive. You're paying euros, pounds, dollars. So if your technology is not generating revenue in those amounts, it becomes expensive to justify filing these applications. But those are the costs. And it's tricky because you have to almost forecast 20 years into the future, because that's how long a patent lasts, to determine whether you're going to make money or not. But that's the ballpark timeline as well. And when you're filing internationally, that can be very expensive. You file in the US, the cost is 50 to 70,000 Rand. You file in Europe, it's 80 to 100,000 Rand. And it's just the filing cost. You have to almost multiply that cost by a factor of 2 to 3 over a period of 3 to 4 years, because you have to convince these patent offices that you have something that's novel and inventive. So the entire process can be very expensive. But if you're just looking at South Africa, the provisional patent, 20 to 30,000, and then at the end of the 12-month period, you file something called a complete patent, and that's at almost the same cost as well. So in South Africa, you can get a granted patent in South Africa for about 50,000 Rand. It's not unheard of, and even less. Trademarks, the trademark office in South Africa does examine trademarks, and they won't grant your trademark unless they confident that you have a valid trademark. So the cost of a search to see whether or not the trademark is available for you to use is about 5,000 Rand. And to file a single trademark in a single class is about another 5,000 Rand. So it's not as expensive as a patent, but it's a different value that you're adding. If you're trying to protect technology, you can't really do it with trademarks. You have to protect it with the patents or designs, whereas trademarks just protects the branding. And the time frame for trademarks is about 3 years to get granted. South Africa, you can get a granted patent very quickly, actually, because it's not examining. We can ask the registrar to please expedite grant. So you can get a granted patent within a year or two. And registered designs, the ballpark costs are between, say, 12 to about 20,000 Rand for South Africa. It's just a single filing, and then you have 6 months worldwide to file designs in other countries. So those are generally the ballpark figures.
Okay, colleagues, I know we are 2 minutes over time, but there's just 2 more questions left. So a question on copyright. If we design and develop a software product for a customer that pays for the engineering hours and he owns the IP, does this imply that the customer also has copyright ownership?
So, as I mentioned, Ibulela, I mean, just to the person asking the question, copyright in computer software, unless these people are full-time developers, will be owned by the contracting developers, unless there's a written assignment to transfer the ownership over to the requester. So in the example that you described, unless there's agreement in place to say that I think if people pay for services, I think they're generally expecting to get the ownership. So most developers know about it, and most developers will assign it over, and they're willing to assign all IP over to the person that's commissioning the work or commissioning the R&D. But strictly speaking, when you apply the strict rules of IP, the question is who invented something? Is it novel and inventive, and who invented it? So if the answer is, well, it's the developer, then the developer will be the inventor. Unless, and then there needs to be an assignment of that invention over to the person that commissioned it. Similarly, if I'm the person that said, well, the developer needs to write this code for me, it needs to be assigned over in order for them, written assignment, in order for it to be validly transferring ownership. So it's critical that parties at the outset engage and contract to determine who's going to own what. It's much easier to start negotiations when people are clear what they own and what they don't own, than trying to untangle a mess at the end. It's legal and a costly nightmare sometimes.
Okay, so research project published in a research journal, who holds copyright and who holds the IP?
Look, it really depends on the IP and IP. When I say IP, IP, like I said, it's a whole range of IP. It's patents, trademarks, copyright. So let's just say I've come up with this great technology or great way of doing something, and I represent quite a few universities, and sometimes the research project is subject of a published paper. So what would happen is that the university would file a patent, which the university will own, and then the copyright is dealt with separately as a separate form of IP. And that really depends on the research journal. Some research journals have agreements in place with the universities that they will not own the IP, but they are able to use the IP. They have use of copyright to publish, to republish, to do things like that. And sometimes they will say they want the ownership of the IP. So it really depends on the research journal itself. But in a nutshell, you will, if you are writing a research paper, and your employment contract with your university or your agreement with your university is silent about the copyright, you will own that copyright unless there's something in writing that moves the ownership of the copyright over to somebody else. So for instance, if you look at your employment contract with the university, if they say that the university will own all the copyright, then the university will own all the copyright. So it really is taken on a case-by-case basis. So review the agreements in place. And if you're in doubt, and if you're at university, contact your technology transfer office. These people, as I said, they're highly skilled individuals. I mean, we work with them very regularly, and they know all about the forms of IP and how it affects your rights.
Okay, Vishen, and the last question is, can a patent be re-registered?
No. So it's interesting. That's a very good question, actually, because it ties into the philosophy of having a patent. Because you must realize that a patent is almost a legal monopoly. You are telling people it's anti-competitive in nature. You can't do this. Just because I invented it, you can't do this. So you can understand that it's a powerful right. And the premise and the theory behind it is that in exchange for this monopoly of 20 years that you're going to give the inventor, they have to disclose to the public whatever it is that they're doing. So if I'm coming up with a new way of doing something, and a prime example for that would be the the telecoms industry back in the 2000s and the 2010s and whatever it is. I mean, in the early 2000s, cell phone technology really wasn't at the level it is today. It was really bad. But what kept on happening is all these big players, your Nokias at that time, no one really knows about Nokia now, but the major telecoms players like Ericsson, Nokia, and so forth, would keep on innovating. And what happened was that one person, one organization would innovate, they file a patent, and they have to disclose to everyone else how they did it. And then you'd have Sony looking at what Ericsson did and said, hey, that's cool. We can use that to build on that. And they would build on that and then move the industry further and further. And that's the premise of having a patent system in the first place, is that you disclose to the public and then you enable the public to invent on what you've done. So you move technology forward. So that's the same reason why patents cannot be registered. You file your patent, you get your monopoly for 20 years. After the 20 years is over, you've got your monopoly. You now have to release it. Everyone else can use it now. But what happens in practice is that people are clever. You use strategies to maximize this time that you have. An example I use is the Weber Bry stand. That's a key example. They use all the forms of IP to their benefit. The monopoly period that they have for their patents and their registered designs was 20 years and 15 years or whatever it is. But in that time period of 20 years, they pushed their brand. They pushed the Weber brand very aggressively internationally. So even though the Weber Bry stand's patents and designs have fallen away, I can walk into a game store and buy a Kodak Bry stand that looks exactly like a Weber. I think it's fine. It's half the price. It does the job. But my dad will not buy, a Kodak Bry stand because it's not a Weber. Because Weber really indoctrinated everyone with their brand and their trademarks. So they relied on one form of IP which is immortal in nature, with another form of IP that gives you this ring fence to grow this brand. So you want to be doing that. You want to be creating this ring fence around your offering and using these IP tools and these intellectual property rights as tools to move your business forward. And that's why I mentioned that it needs to be forming part of your business strategy in any business strategy.
Okay, thank you, colleagues, for a very engaging question and answer session. We'll now proceed with the lucky prize draw, where one of you will walk away with a 1,000 Rand Takealot voucher. So I'm just going to choose a name from here. So the winner is Lindiwe Panchwa, the Managing Director at MTY IT Solutions. Congratulations, Lindiwe. A Takealot voucher with 1,000 Rand will be on its way to you shortly. So in conclusion, I would like to thank Vishen for sharing his knowledge and insights. I think that we're walking away from this session knowing much more about IP. And I'd also like to thank my colleague Davey for assisting us in hosting the event. Thank you, colleagues, for attending, and goodbye.
Thank you, everyone, for your time. Thank you, Ibelela and team at Perco for the opportunity. Really appreciate it.